All right, guys. A little more. It's a little OceanGate stuff. Apparently, they're getting sued. Majorly sued. It's a video by Legal Eagle. I'm curious about it. You know, I remember that whole story. That was crazy, man. That was crazy. Let's see what we got going on here.
Who could have possibly foreseen something going wrong with the Titan sub? Well, the lawyers, that's who. But will all of this legal paperwork save OceanGate, the company, from ruinous lawsuits?
Cowabunga, you know what I'm saying?
And will the estate of the victims be able to recover anything? Well, before the OceanGate disaster, CEO Stockton Rush was bullish on the submersible that he built to visit the Titanic. He scoffed at the complex navigation systems used by other commercial subs.
Check it out. I actually have the I have a navigation system for the sub right here. Check it out. It's right here. It's actually better than the one they were using. They were using a Logitech. I'm using an actual PlayStation 5. You know, so I mean, I just use better tech. I'm just built different.
We have one button, that's it. This is to other submersibles what the iPhone was to the Blackberry.
Rush was proud that he patched together off-the-shelf items from Camping World and charged people $250,000 a piece to travel 2 miles under the sea.
Jesus.
By taking off-the-shelf parts and sort of MacGyvering them together.
Yeah, pretty much.
Does that not raise anybody's eyebrows in the industry?
Oh yeah. Oh yeah. Yeah, no, I'm definitely an outlier.
And despite some obvious red flags, 5 people were willing to accept extraordinary risks in order to see the Titanic's ruins.
I mean, like, listen, because if they're getting sued, fine, I don't care. But you know, if the people that died were poor, nobody would be getting sued. You know what I mean? Like, I don't understand how. First of all, it's crazy that you would make some dumb, like, unsafe submarine, and people would actually pay. I mean, I don't know. Why would you pay for it? Especially if you're rich, you should know. I feel like you should know better. You mean you had access to all the education, and you still decided to take $250,000 to go into Tudacan?
And they
just do what I do, pretend in a cardboard box as a child.
Now join the exclusive club that they were so fascinated with. And there's no question that they knew that this was dangerous. They signed liability waivers that warned them that the trip could expose them to death. Now, as many...
My question is, though, my understanding, and I could be wrong about this, are liability waivers like 100% foolproof, though? My understanding was that they're not. Like, there's like a reasonable amount... There's like an aspect of it that's like a reasonability. Like, if they're... Does that make sense? Where you could waive off liability as long as there's a kind of a reasonable like circumstance involved, but if it becomes unreasonable in some capacity, you're not going to be able to win that.
People assumed everyone who paid to take the voyage signed a waiver of liability with a choice of law clause. The OceanGate waiver that the passengers were required to sign says that disputes would be governed by the laws of the Bahamas. Quote, any disputes related to or arising from either the operation or this release shall be governed by the laws of the Bahamas. Now, the Bahamas judicial system is based on English common law, and whether families can sue depends on how the country handles
yes, common law. I see a lot of those people in Florida. They go, I'm not driving. I don't need a license. I'm traveling. I'm traveling. A lot of basketball players. Isn't that crazy? Funny joke, right?
liability waivers. The language of the waiver makes it clear that the participants are engaged in activity that could lead to death. Quote, this vessel will be subject to extreme pressure, and any failure of the vessel while I am on board could cause severe injury or death. It discloses that the Titan, quote, has not been approved or certified by any regulatory body and may be constructed in materials that have not been widely used in human-occupied submersibles. The waiver says that support vehicles are also not designed for passengers and could become more dangerous in rough seas. And the waiver says that these risks cannot be eliminated. Quote, I understand that such risks simply cannot be eliminated from any operation. The risks include without limitation, loss of footing, slips and falls on deck, particularly in inclement weather, harm from falling objects on non-passenger vessels, drowning and malfunction or failure of the submersible leading to death or serious injury. And the participants had to acknowledge this statement as a condition of going on the trip. Quote, in signing this document, I acknowledge that if I die, am hurt, or incur property damage during my participation in the expedition, I may be found by a court of law to have waived my right to maintain a lawsuit. Now, in the US, liability waivers only cover ordinary negligence. If a company's act constitutes gross negligence or intentional harm, the liability waiver just simply doesn't apply.
Okay, right. That's what I was talking about. That's what I was referring to. Because wouldn't this be considered some kind of gross negligence? I mean, I don't, maybe not negligent, but yeah, right? Because they're not even like fucking approved with any of the things that they're using. Wouldn't you consider that some kind of negligence? I guess maybe not. I don't know. Bro, stop hitting me. I'm getting mad at you.
And here, ordinary negligence encompasses mistakes due to inattention or general incompetence, just as simply to maintain industry standards. In contrast, gross negligence occurs when someone purposefully fails to use reasonable care to ensure someone's safety. For there to be gross negligence, you need to show that the defendant was more than careless, that they were reckless and engaged in behavior that might even appear to be.
Sounds pretty reckless to use a fucking Logitech controller. Maybe I just don't. Maybe I'm just the idiot. I don't know. Maybe I just don't know anything. But yeah. Oh my god, this game.
Deliberate. Now, the hallmark of gross negligence is that the defendant showed a total lack of care and disregard for the safety of others. And here, that is definitely a distinct possibility. We'll talk about this in detail later, but here, deep sea exploration specialist Rob McCollum told Rush in writing before the disaster that he sounded just like the makers of the Titanic. Quote, "In your race to the Titanic, you are mirroring that famous catch cry, 'She is unsinkable.'" Rush emailed him back saying, quote, "We have heard the baseless cries of 'you are going to kill someone' way too often. I take this as a serious personal insult." But McCollum wrote back to Rush again in March of 2018 saying, quote, "I think you are potentially placing yourself and your clients in a dangerous dynamic." Who knew how right he was going to be? So clearly at least one person thought that Rush had a complete disregard for the safety of other people, though that was an opinion that was shared by David Lockridge, a former employee of OceanGate.
That looks like a really big blown up sex toy.
And the members of the Marine Technology Society. And when considering whether there was gross negligence, a court considers whether a rational person in the same situation would have known that there was foreseeable harm. And witnesses say that in the years after Lockridge and McCollum issued their warnings, the Titan showed signs of shoddy design. The Titan was severely damaged after it was struck by lightning in 2018. Rush said that the lightning strike damaged 70% of its internal systems.
How the fuck did it get hit by a lightning strike? Underwater? Well, I guess it wasn't underwater, huh? I guess submarines aren't always submerged. Silly Papagat. You silly goose. Okay, just turn around for the last second.
Forcing the company to delay a planned voyage to the Titanic. And that's really just the tip of the iceberg.
Lightning can do weird things. That pushed our testing back, and we ended up having to cancel that. It was back in 2018.
Sub-expert Carl Stanley took a trip on board the Titan in 2019 and reported hearing cracking sounds in the hull.
I'm so good at
and
this
after
game.
the trip,
Holy fuck.
Stanley emailed Rush with his concerns that the carbon fiber hull might not be able to withstand the deep dives. In fact, he wrote that during his trip, it, quote, sounded like a flaw defect in one area being acted on by the tremendous pressures and being crushed/damaged. In 2020, the hull had to be rebuilt because of the cyclic fatigue that reduced its depth rating to just 3,000 meters, which was well short of what was needed to get to the Titanic. And both Lockridge and McCollum thought that the window was a major mistake because it would be exposed to around 6,000 pounds per square inch of water pressure, which is the equivalent of about 2 tons of water at that depth.
Yeah, I think that I actually have could have had a solution for that. Don't go. I mean, like, listen, it's terrible that this happened. But I have a hard time feeling that bad for everybody. Although I guess to the rich people, they're thinking like, oh, this went well before. I guess why wouldn't it go well? Why wouldn't it go well now? I guess that's the logic that they're operating with. I guess it makes sense. Still, did they know about all this other stuff?
However, in the summer of 2021, Rush told YouTuber Alan Estrada that the window was made of plexiglass and that he was comfortable with that because it was, quote, 7 inches thick and weighs 80 pounds.
I mean, same, you know. Okay, let's move on.
Acrylic is great because before it cracks or fails, it starts to crackle, so you get a huge warning if it's going to fail. And I'll let my friend over at Real Engineering explain why this is bonkers.
An acoustic monitoring system like this is akin to setting up a camera to warn you thunder is coming. You will see the lightning before the thunder, but the time between them is minimal.
So if the window couldn't withstand the pressure and the people in the sub could hear the window cracking, it's probably too late. The entire submersible was at risk of imploding before it could surface. And several former passengers on the Titan said that they thought it was completely unsafe. One passenger said that during the Titan's descent and ascent, a fluorescent glow stick was used instead of the lights to save energy. He compared the
What the fuck? They used a glow stick instead of actual lights? That's incredible. Wow. Jesus Christ. I wonder to any of the people who actually went on this trip, like then survived. What was the experience like? Did they even enjoy it? I would have been shitting my pants the entire time. Because that's just that's terrifying. You know what I mean? I wouldn't be able to enjoy it because I would be so scared the entire time. That's bonkers, dude. Holy fuck. That's just fucking crazy to me. Why would you even pay for that?
The dives to riding in a, quote, car that you drunkenly drove into the ocean, steered by a video game controller. And former passenger Arthur Loibel said that on his 2021 voyage, the bracket of the stabilization tube, which is the thing that actually balances the sub, tore and was hastily reattached with zip ties. Simpsons writer Mike Reese said that communication failures happened on all 3 of the dives that he went on in 2022, but the problems continue.
He took 4 trips, it says. You took 4 trips, bro? Why? It couldn't have been that good. What was under there? It's just cold and dark. Yeah, I like this so much. I went 3 more times. This dude spent $1 million. My man spent $1 million on a fucking on this shit. I mean, we could have. I feel like we could have used this money so much more effectively. You know what I mean? Like, if you spend $1 million, because it was $250,000 a shot. If you're able to spend $250 million or $250,000 to go into a fucking sardine can under the water, you have too much money.
Also in 2022, the Titan lost control and started spinning in circles at the bottom of the Atlantic when it was just 300 meters from the Titanic wreckage. And something happened to the thrusters that made the Titan unable to move forward or backward. This harrowing moment was captured on a BBC documentary.
Am I spinning?
Yeah.
Oh my God.
And Scott is like, oh no, we have a problem.
Houston?
I was thinking,
Wow.
we're not going to make it.
Oh no.
We can't
Why'd
go
you in the
anywhere
first
but
place?
go in circles.
YouTuber Jake Kohler took a trip on the Titan just days before its doomed trip, and he said that the communication system went down during a routine test dive.
You imagine that guy, that was the one that went down. Dumb. Then the headlines would have been like, "Fucking dumbass YouTuber passes away in an oceanic dive." Like that would have been the fucking headline of everybody's video. It's true. It's just the truth. Jesus Christ.
The trip was canceled due to weather, but Kohler felt like the vessel might have imploded if the dive had went ahead. One of the passengers who was killed in the Titan disaster was Paul-Henri Nargeolet, who was a Titanic expert. He had worked closely with the organization that manages the Titanic wreckage.
Probably the only guy that went there for like actual, like the only person that actually had a justifiable reason to want to go there. I'm an expert on the Titanic. I want to go see it. Only one that makes sense. And he passed away.
Jessica Sanders, who heads the Titanic organization, said that she regretted giving Nargeolet the green light to go on the expedition. She said that Rush had told potential passengers that the Titan sub was, quote, way safer than flying in a helicopter or even scuba diving or even crossing the street. And note here that there's a big conflict between what the waiver said about the expedition being dangerous and deadly and what Rush was confidently telling potential passengers. Gross negligence means that the person has fallen so far below a reasonable standard of care that their actions are considered reckless or even deliberate. So it's legally acceptable to engage in hazardous activities, but that doesn't mean someone can't ignore obvious risks. So if Bahamian law upholds the liability waivers, it's likely the families will pursue litigation in their respective countries, regardless of what the choice of law provision says. But that doesn't mean that this would be an easy case.
So they're going to spend $250,000 just getting their fucking deceased relative or whatever onto the death box, and then they have to spend more money for a lawyer. How do they have all this money, bro? You're too rich. You're too rich, dude. That's it.
To bring because courts in many jurisdictions tend to uphold liability waivers if they are specific, and this one was very specific. As a general rule, clauses limiting liability are valid and enforceable under common law unless they violate public policy or the damage was the result of willful or wanton conduct on the part of the defendant. Some jurisdictions have statutory exceptions to this general principle. Generally, a pre-injury release will only be enforced if, in clear and conspicuous language, it explicitly indicates the intent to release the provider from liability for injury caused by that party's own conduct or negligence. Each jurisdiction applies different factors when assessing a public policy exception, but most of them focus on 2 things. If the terms of the waiver are clear and unambiguous, then a court first considers whether the party being released provides a necessity or other essential service, and second, whether the agreement is inherently fair and not unconscionable. Risky recreational activities like skydiving or scuba diving are generally not public necessities or essential services, so when it comes to the first factor, courts tend to favor the released parties. When it comes to the second factor, whether the waiver is inherently fair, courts weigh the respective bargaining powers of the parties. Did one party have more leverage than the other? Was the injured party coerced into inherently risky behavior?
Interesting. So are they not gonna? So it sounds to me okay. So what it sounds like, obviously, you didn't need to do this. You know, I guess you'd consider like flying an airplane. You kind of need to do that, so it needs to be safer, I guess. But then also, these are a bunch of rich people. How could you even coerce them into doing anything? You know? Where's the fucking power dynamic there? You know, that's just a dumb decision. Jesus Christ. You know what they should have done? They should have went to a Blink-182 concert instead. Anybody who does that, smart in my book. Smart in my book. These guys are shooting fucking crossbows with plungers at me. Why wouldn't you just shoot a gun? Shoot me with a gun, you know? Like, this doesn't make any sense. But okay.
Did the owner or operator withhold information from the passengers? Did the passengers understand how hazardous the trip would be? Usually, liability waivers are presented as something you have to sign or else you can't participate in that activity. Some courts find this problematic because it's a take it or leave it proposition and the participant doesn't have the ability to negotiate. But still, more courts conclude that if a person voluntarily participates in an extreme activity, unequal bargaining power won't actually invalidate the waiver. So for example, courts have concluded that whitewater rafting and skydiving are both personal choices and not essential services, so there's no real bargaining advantage. A person can't really be compelled to participate in those particular activities, though there are courts that view it differently. The Oregon Supreme Court, for example, found that an unequivocal release signed by a plaintiff injured in a snowboarding accident violated public policy. The snowboarder could have avoided all the risks by not using the defense facility, but the court still concluded that the owner of the resort was in a superior bargaining position because the plaintiff had, quote, no meaningful alternative to defendant's take it or leave it terms if he wanted to participate in downhill snowboarding. Though that is a minority position.
Radical,
the thing about
dude.
Devastating injuries and catastrophic events is that they can happen at any time, often without warning. So if you or a loved one is seriously injured in a submarine accident, or more likely a car accident or a medical malpractice accident or anything else, you can call my law firm, the Eagle Team. We can help. A free consultation
Is this a
just
plug?
a phone call away, and the link is in the description.
That was a fucking epic plug. I didn't even see that. I didn't see it coming. Epic plug. Cool.
Now back to the submarine shenanigans. Though in an interesting twist of fate, lawyer David Concannon was scheduled to be on the OceanGate expedition, but he actually canceled because of a client matter. Concannon is an experienced diver who had been to the Titanic before.
A fucking lawyer was about to go there? Oh, I accidentally changed the... I changed the language. A fucking lawyer was gonna go on there? What's his excuse? What, did he not read it? That's crazy.
And he is listed as an advisor to OceanGate. He also has an experience suing companies who are engaged in hazardous underwater operations, even when the...
Was he going there just to sue? Could you imagine he's like, I'm gonna go on it just so that I could sue if after it's hazardous and something goes wrong. I saw the stuff, bro. How is this guy not getting hit? That's what the fucking... I saw something about some guy, the lights went out, they were using glow sticks. I'm gonna go in there just so I could sue them. I wouldn't doubt it. Good thing he didn't go on that one, because he wouldn't have been able to sue, because he'd be dead.
The plaintiff signed liability waivers. And Concannon actually settled the case against a dive shop and the Professional Association of Diving Instructors, or PADI, despite the fact that the diver signed a liability waiver. And that shows us how OceanGate might be liable if the applicable law was similar to Montana's
that lawyer's
law.
probably trying
When
to set him
Linnea
up.
Mills died in a diving accident in Glacier Park in 2020, her family sued the dive shop Gull Drive and PADI for negligence, wrongful death, and infliction of emotional distress. Mills was 18 years old when she signed up for an advanced diving class. The class was supposed to cover situations like high-altitude diving and cold water diving with a dry suit. However, the instructors didn't have a permit for the dive, which took place at the national park after the park had closed. The dive shop instructors were certified by PADI, but did not have much experience in the diving situations that they were supposed to be teaching. And instructors pressed forward with the dive without doing a gear check. They gave Mills a dry suit without an inflator nose, and she also had a regulator unsuitable for cold water use. A GoPro video of one of the other students showed Mills struggling with the pressure in her suit when she was 60 feet down, and the video revealed that Mills couldn't breathe and had too much weight on her to actually ascend. Mills was crushed by the pressure of the water. And this wasn't Gull Dive's first fatality. In 2019, Gull Dive rented scuba equipment to a person not certified to scuba dive, and the man immediately drowned upon entering the water. Gull Dive...
How the fuck does that happen? The fuck are these? How do you die immediately after you get into the thing? That's insane.
And Patty argued that the disclaimer form that Mills signed absolved them from liability. However, a judge disagreed. Montana's law allowed waivers and releases to be enforceable except when there is gross negligence or defective equipment. Those things can't be waived because Montana's law, quote, does not preclude an action based on the negligence of the provider if the injury, death, or damage is not the result of an inherent risk of the sport or recreational opportunity. When the judge ruled that the case should go to trial, the defendant settled. But of course, the OceanGate disaster didn't take place in a lake in Montana, it took place in the middle of the Atlantic. And when a passenger or seat worker dies aboard a ship, family members can file a lawsuit under the provisions of the Death on the High Seas Act, known as DOSA. That act applies to cases involving vessels and aircraft that go beyond the 3 nautical mile limit off the coast of the United States and its territories. A plaintiff has a cause of action if the seaworker died due to an unseaworthy vessel or through other provable negligence on the part of the ship owner. The vessel in question must have been engaged in what could be recognized as a maritime activity. And in addition to maritime employees, DOSA also covers civilian passengers of a maritime vessel. To succeed in a DOSA claim, a plaintiff has to prove that the vessel wasn't seaworthy. And a plaintiff can prove a lack of seaworthiness if the vessel had significant mechanical defects or was otherwise incapable of handling the situations such vessels could reasonably be expected to encounter while at sea. A plaintiff can also prove unseaworthiness if the owner of the vessel behaved negligently in connection with their responsibilities as a ship owner. And here the facts suggest that OceanGate may have breached its duty to provide a seaworthy vessel for the crew and passengers. When Rush was developing the Titan, he started with an existing vessel called the Cyclops 1 that was constructed with engineers at the University of Washington. The engineers used an off-brand PlayStation 3 controller to drive the sub. However, Cyclops 1 was only built to withstand depths of 500 meters.
How many meters is the Titanic? At least 501 meters, am I right? Is it that normal? It is normal to use like a fucking game controller, right? Isn't it? That's just weird to me that it would be so normalized. You think they'd have some kind of better navigating system, but I guess... Hey, like they say, guys, capitalism breeds innovation, am I right? Am I right or what? I guess I'm right.
Nevertheless, Rush decided to keep most of the design elements of the Cyclops for the Titan, but engineer it to go 8 times deeper. When Rob McCullum visited the company's shop in Washington, he thought the PlayStation controller was ridiculous. Quote, and now you have the hand controller.
I personally think an N64 controller might be better because there's more buttons, right? I think that's all it really required. The more buttons, the better. It'd be a Sega Dreamcast controller. To be honest with you, though, all jokes aside, mouse and keyboard is the best control that you'll ever have in any game you ever play, right? Or any boat you ever drive. You know? It's true.
Talking to a Wi-Fi unit, which is talking to a black box, which is talking to the sub's thrusters. There were multiple points of failure. Rush said that the whole comm system ran on Bluetooth, and Rush ignored all the feedback. And in particular,
how does Bluetooth work? I was about to say, can you do Bluetooth underwater? But I'm thinking Wi-Fi.
decided that the Titan's cylindrical midsection would be made of carbon fiber instead of titanium.
Carbon fiber is a great material. It's better than titanium. It's better than a lot of other materials.
The Titan was completed in 2018.
Is that true?
But experts had concerns about whether the sub could withstand the
Use a Wii controller. Come on, it's not working. Use the Xbox Connect. That's what I think they should have used. Use the Xbox Connect, bro. Just fucking... My wife was telling me a story. We went to, not Dave & Buster's, it was round 1 the other day. And she saw the Fruit Ninja game where you, like, tap and you run your finger across the screen and stuff to, like, cut the fruit. And she's like, you know what's funny? When I first did this when I was younger, at, like, a Dave & Buster's she had gone to, I had the game for the Xbox Connect. So I didn't actually touch the screen. I was just waving in front of the screen, like dancing in front of it, trying to cut the fruit, and nothing was happening, and everybody thought I looked silly. I thought that was funny.
Rigors of deep sea exploration.
Use a Just Dance pad.
Real Engineering explained why carbon fiber was a problematic choice.
Carbon fiber composites aren't really known for their compressive strength.
Yeah, I knew that.
They work best in tension. Great for airplanes that are pressurized from the inside, where the pressure inside the fuselage works to expand the circular cross-section, putting the fibers in tension. For a submarine, the pressure will work to compress the hull, placing the fibers primarily in compression. This immediately set off alarm bells in my mind when I heard.
That's kind of weird. I get it though. I get what he's saying. When you're in the air, the pressure's inside, so it's pushing outwards. So it's like tightening it in like a positive way, where if it's pushing inwards, it's like crushing it, and it can't handle that crushing tension.
heard of the missing submarine.
You should absolutely check out the rest of Real Engineering's video on it. It's really incredible. But he explains that the carbon fiber is great for buoyancy and that Rush thought that this would help the sub float right to the surface, whereas steel and titanium hulls require foam layers. But Rush wanted to avoid the foam layers to cut costs.
This is where things get
So what? To cut costs? What do you mean? So you're saying that it could have been exponentially more safe, but they wanted to save a little money? You guys are charging $250,000 to go underwater in a metal tube controlled with a fucking Logitech controller. Why did you feel the need to save money? You already saved money. I feel like there's how much more money could you save? That's fucking crazy to me. That's wild. Holy shit. That's just insane. Okay. Well, you know, I guess those rich people got it back to them because they're probably rich for fucking exploiting workers anyway. Just for some jobs. But, you know, yeah, save money, guys. It's the priority. Always save money.
iffy. OceanGate had no idea whether it was up to the task or not. And we know this because they admit it in their own blog post, justifying their decision to not test the vehicle with a regulatory body.
OceanGate's former director of marine operations, David Lockridge, wrote a report in which he concluded that the craft needed more testing and stressed the potential dangers to passengers of the Titan as the submersible reached extreme depths. Lockridge thought that the carbon fiber hull would come apart after repeated dives. Lockridge met with Rush and other company executives and laid out his concerns. And he also claimed that the Titan had other significant design flaws. For example, the viewport was only certified to work in depths up to 1,300 meters. And to reach the Titanic, the Titan would need to go 4,000 meters under the ocean's surface. And there are private agencies that inspect and certify submersibles, but Lockridge said that OceanGate didn't want to pay for independent certifications. The company fired Lockridge and then sued him for disclosing confidential information. OceanGate said that Lockridge was not an engineer and that the company's own testing of the hull strength was better than the independent testing that Lockridge had recommended. But Lockridge was...
yes, of course. Guys, nothing is better for a company than the internal review. The external reviews of unbiased sources on the outside, those are much less reputable. You should basically, like, let's just say, for instance, let's say like a Walmart was engaging in like fraudulent behavior, allegedly. You should allow Walmart to do their own inspection of it instead of an outside source, because who's going to be more honest? Huh? Obviously, it's going to be Walmart because they have so much more investment into wanting to be good people, doing the right thing. That's why the investigation's happening in the first place, you know?
was not the only voice sounding an alarm about the Titan's design. Director James Cameron has designed submersibles himself and visited the Titanic many times. He said that the carbon fiber construction of the Titan was, quote, fundamentally flawed, and that everyone in deep sea exploration knew about it.
You know, this is a mature art, and many people
Brad
in
Bresson
the community
super
were very
chatted $5. It's a little irresponsible Papa Gut wasn't on the sub to stop it from breaking. He's simply built different.
That's true, actually. That's a good point. You should have had me on that sub. I could have stopped it. I could have stopped the water. I am built different. Wow, that's backfired on me. Holy shit.
concerned about
Thank
this
you for
sub.
$5.
And a number of the top players in the deep submergence engineering community even wrote letters to the company saying that what they were doing was too experimental to carry passengers and that needed to be certified and so on.
And a few months after Lockridge was fired, 38 members of the Manned Underwater Vehicles Committee of the Marine Technology Society wrote Rush a letter stating that, in their unanimous opinion, he was misleading the public and risking a catastrophic outcome. Quote, "Your marketing material advertises that the Titan design will meet or exceed DNVGL safety standards, yet it does not appear that OceanGate has the intention of following DNVGL class rules. Your representations, at a minimum, are misleading to the public and breach..."
That's a good point. You would have just drank the water, Carlo. I think that's a good idea. Then what, like, you know, then the water couldn't have made you drown, you know? I think the most fucked up part of it is that, like, people were looking for like several days to see if they could, like, rescue these people. But the problem was that they were, I think they died almost like immediately. There was like an implosion that killed them all. Isn't that terrible?
breaches an industry-wide professional code of conduct we all endeavor to uphold. Now, obviously, this is an incredibly damning letter. Lawyers who file negligence lawsuits have to prove that the defendant didn't follow the ordinary standard of care, or worse, knowingly didn't follow a standard of care. And usually that means hiring an expert witness in the field who can articulate the norms of an industry and evaluate whether the defendant's conduct met those norms. And in this case, we have experts in the field saying that the Titan didn't measure up to industry standards before the accident even occurred.
Jesus.
And the experts concluded that Rush needed to start with a prototype that would be validated by third parties in order to protect all of these submersible occupants. And in a 2019 blog post, OceanGate said, quote, bringing an outside entity up to speed on every innovation before it's put into real-world testing is anathema to rapid innovation. And Rush told Smithsonian Magazine that the industry was, quote, obscenely safe because they have all these regulations, but it also hasn't innovated or grown because they have all these regulations. So while on the face of it, this looks like the kind of thing that would be covered by the Death on the High Seas Act, it's actually more complicated than that, because it's not perfectly clear that the Titan was a vessel for the purposes of the act. And ironically, OceanGate might be covered by the same exception to DOSA that White Star Line used to limit its exposure to the Titanic disaster itself. So let's go back to 1912 when the Titanic sank off the...
Didn't the Titanic sink because of wood screws? Or is that just me not, like, I think my Jaji told me that when I was younger, and I've always believed it. Is that true?
Coast of Newfoundland in its maiden voyage. The luxury steamship was owned by White Star Line, which bragged that it was virtually unsinkable. Yet, as we all know, when the ship set sail, it swiftly ran into an iceberg, killing 1,517 passengers. And it turned out that the ship had a design flaw. The walls separating the bulkheads extended only a few feet above the waterline, so water could pour in from one of the compartments into another. Surviving family members sought compensation from White Star Line, but the company had a legal trick up its sleeve. The Limitation Act of 1850.
They had the legal trick up their sleeve. They bought the politicians. They had this screwy thing called a lot of money. It's this really interesting legal loophole where they can make sure that they have so much money that they don't have to spend money anymore, even when they kill people. Ah, yes, of course. How could I not see that coming? Why don't we all just engage in that? Then everybody would be rich and we'd all be fine.
One, which was enacted to help prevent ship owners from going bankrupt. The law gives ship owners the right to preemptively file a claim in federal court before plaintiffs have a chance to sue them. The claim limits plaintiffs to the post-loss value of the vessel and its cargo. If the vessel and cargo were completely lost, the value of the vessel cannot be calculated in the owner's assets. In 1915, a judge found that White Star Line was not guilty and had no knowledge of the errors that led to the catastrophic loss. And that meant that they didn't have to compensate the families for the fatalities.
Incredible.
And since the accident was considered the fault of the Titanic's captain and crew, the company's liability was limited to the total of passenger fares, the amount paid for cargo, and any salvage materials that were recovered from the wreck. And the company settled for $664,000 to be divided among the survivors. And the same
How much is that in 1916? Inflation calculator. Oh, when I typed that in, inflation porn came up. And I was like, why would that come up unless I've looked at it before? 664,000. In, we'll say January of 1914 is right now $20,259,237.60. Incredible.
Limitation Act exception.
It doesn't seem like a whole lot of money considering, I mean, maybe it is, I don't know.
Might provide OceanGate with a way to avoid liability since the post-casualty value of the Titan is basically zero. But there's also another wrinkle to this law. In 2019, a dive boat carrying 33 passengers and 6 crew members caught fire and sank off the coast of California, resulting in the deaths of 34 people. Days after the boat sank, its owners filed a limitation action seeking to limit their liability to the value of the vessel, which was effectively zero. In response, Congress enacted the Small Passenger Vessel Act, which carves out certain small passenger vessels from being able to limit their liability to the value of their vessel. This is an exception to the exception, and these smaller vessels can now be held liable for any and all losses arising from a maritime casualty. And the act defines a small passenger vessel as one carrying not more than 49 passengers on an overnight domestic voyage and not more than 150 passengers on any voyage that is not an overnight domestic voyage. The SPVA could apply to the Titan, but the law is new and has yet to be tested in court. And there are other open questions, like whether a submersible is considered a vessel for the purposes of the SPVA, and whether American law would even apply in the first place. Because there are lots of jurisdictional questions too. The United States and Canada have launched investigations into what happened to the Titan. However, it isn't clear which country would have jurisdiction over the legal claims. OceanGate Expeditions, the company that owned and operated the Titan, is based in Everett, Washington. The company shut down its Everett operations after the accident, and the Titan was launched.
I mean, did they shut down the operations just to try to potentially dodge getting sued? Was that the whole, like, this kind of seems like it to me. I mean, what other play do they really have there? Other than to just, like, dishonestly do that?
From a ship called the Polar Prince, which is flagged from Canada. The people on board the submersible were from England, Pakistan, France, and the United States. And of course, the wreck is in the middle of the Atlantic. Now, the United States Coast Guard regulates passenger-carrying submersibles, and submersibles with fewer than 6 passengers have not been subject to inspection, which is probably why Stockton Rush's sub carried only 5 people. U.S. regulations state, quote, because of the unique design and operating characteristics, as well as the inherent hazards of underwater operation, an uninspected submersible may be permitted in U.S. passenger operations only if it is designed and constructed to a recognized industry standard. That means it's illegal to transport passengers in a sub that is experimental. Rush classified the passengers as mission specialists and classified...
Yeah, I mean, like, they're not really going anywhere, right? Well, they're going to the Titanic, so I guess, would that be considered like a destination? Right?
Uninspected submersible may be permitted in U.S. passenger operations only if it is designed and constructed to a recognized industry standard. That means it's illegal to transport passengers in a sub that is experimental. Rush classified the passengers as mission specialists...
Wow. What's the specialty? What you don't have to have like some kind of a degree attached to being a specialist of anything? That's incredible.
And classified their
I have a bachelor's in missions. What the fuck?
$250,000 fee as a donation in order to evade the implication that they were just ticket buying passengers. But industry experts knew that
what? How do you just classify a payment as a donation if it's mandatory? That's like those guys in the malls who walk up to you and like, yo, man, I got my mixtape is free. You don't have to pay for it. But we accept donations. And I'm like, well, I don't really want it. You know, I don't really want your mixtape. And then they give it to me anyway. They're like, no, you take it. And I'm like, okay, I just walk away with it. Because this actually happened to me. And then after I walk away with it, like, yo, they follow me like into another store and go, like, yo, where's my money? You have to give me money for this. And I was like, no, I don't. Like, I don't want it. Then I had to give back, which is fine with me. It was a waste. It's just a fucking bullshit CD. Like, that's what this reminds me of. It's just the guy selling a mixtape in the mall. That's fucking crazy. But okay.
that Stockton was trying to evade these regulations. William Conan is one of the experts who signed a letter urging Stockton Rush to follow the rules.
What they were doing for tourism would not be allowed in U.S. waters. The Coast Guard would not allow it. It would not be allowed to work in British coastal waters because it would have required it to be certified. Same thing in Canada. And then turns out that they operated in international waters where no Coast Guard has jurisdiction. Well, you found two loopholes.
Well, here's my remedy to this situation. Hear me out. It's a little bit crazy. Just have America own everything. We take over the world. We don't have to worry about this loophole shenanigan nonsense. You know what I mean? We own everything. Won't be a problem anymore. Bada bing, bada boom. We're all set. Everybody wins. We could all be part of the greatest country in the whole world, bro. And then we could fight aliens. Set our sights on the real problems. Aliens. The real problems.
And let's just say it wasn't very wise.
And although the Titan was developed and built in Washington state, the New Yorker reported that the company's legal filings said that the sub would be, quote, owned by a Bahamian entity, will be registered in the Bahamas, and will operate exclusively outside of the territorial waters of the United States. And at this point, while we know that there will be lots of lawsuits, we don't know who's going to have jurisdiction, the status of the insurance of the Titan or of the passengers, and we don't know whether the waiver that they signed will be enforceable or not. But one thing is for certain, Stockton Rush really should have brushed up on his math and science skills, which you can do with today's sponsor, Brilliant. Because Brilliant is the best way to learn math and computer science interactively.
Yeah, well, you know what? I left school for that exact reason. All right, interesting video.